In today's episode, we have my friend Nancy Mehrad joining. She is the CEO and securities lawyer for Registrant Law. In today's conversation, Nancy and I will review the CSA and CIRO's examination findings regarding conflicts of interest as it relates to the client-focused reforms that were published. We'll review the exam findings along with what practices and controls firms can implement to improve their compliance practices. Lastly, we'll touch on what's next. What can firms expect on the client-focused reforms file? Nancy, welcome back. It's always great to touch base again.
Thank you very much, Paham. It's good to see you too.
All right, what's brought us back together is one of the topics of conversation that we chat about often, and it's the client-focused reforms. On August 3rd, the Canadian Investment Regulatory Organization, along with the Canadian Securities Administrators, published a summary of their examination findings related to the conflict of interest practices as it relates to the client-focused reforms. The headline there is that of the 172 firms that were reviewed or examined across the CSA, IROC, and MFDA, no deficiencies related to conflicts of interest were raised for only 37 firms of those 172. So let's have a quick conversation on what ensued there in that examination findings. And from your perspective, Nancy, given that you counsel firms on these various topics, what are the key takeaways?
For sure. Yeah. I mean, I think it's what you said is helpful. And it's important to note that I think some firms did well, as you say. You know, you've got the 1 in 5 of the 172 firms that were reviewed. 1 in 5 had no deficiencies, which is great. But then the other roughly 80% did have deficiencies. And I think of those remaining that did have the deficiencies, you know, there was areas where they did well and there was areas where they didn't do so well. So primarily, for example, 2 in 3 of the firms were found to have inadequate policies and procedures, right? So I think that's really important for firms to review their policies and procedures against what's in the notice to make sure that they're in line with the expectations of regulators in that regard. There are other areas, for example, 53% of the firms didn't have adequate disclosures or they were missing disclosures. And then roughly 1 in 3 firms failed to identify 1 or more material conflicts of interest, or they had inadequate controls to assess the conflicts of interest in the best interests of the client. So I think those were some general areas that firms were found to have not done so well. And there were some positives, and that is that only 17% had deficiencies in training, and less than 10% had deficiencies in record keeping. So that's just a high level, I think, of what the regulators found during those reviews. You asked me about takeaways, and I think what's really important for firms is it's extremely important to read the notice. So you have to really take the time and read it, because it does provide a lot of detailed guidance on what the regulators expect for various items from the CFRs as they relate to conflicts of interest. It's important that you also compare your policies, you compare your record-keeping practices, you compare your disclosures against what's actually found in the notice. I think I mentioned before that there's some really detailed examples in the notice that, you know, we didn't have in the companion policy or we didn't have in the FAQs. So really, and I can point you to 2 examples. For example, you know, referral agreements, or arrangements, there's a lot of detail in there in terms of what the regulators are expecting for referrals in or referrals out. So you got to read that and make sure that you're in line with their expectations. And there's also a discussion in the notice on fees charged to clients. So there's significant comments on the controls or actions or disclosures that are required, where a registrant allows deviations from its standard fee schedule, or where a firm charges their standard fee schedule and their fee schedule changes. So that's also an area that they have to look into. So I think there's a lot. I could keep going on and on with the list of things that are in there, but it's really important that people read it for themselves and consult with their counsel, to see exactly what the expectations are from the regulators and how they're doing compared to what's in the notice, and what changes it can make to be more in line with the regulators' expectations.
Fantastic. That's a phenomenal overview, Nancy. Now, you touched on a couple of pieces I want to kind of drill into, and to your point about kind of this examination findings and how it sheds light on specific examples of where the industry can, to your point, address their policies and procedures, train their staff, mitigate their conflicts, if not eliminate them. One area that's come up quite often is the concept around, or the conflict between having a proprietary product offering, as well as making sure the products that are in that proprietary product offering are in the investor's best interest. The regulators talked a little bit about sort of doing that range of reasonable alternatives analysis in this examination findings. And also, if a firm has, we still get this question from our clients, if a firm has a proprietary product offering, how can they go about mitigating their conflicts in light of the examination findings?
Right. And so that's a good point, because I think there was some important additional information that was provided, or perhaps more detailed guidance that was provided that firms may not have caught in the past. So, the usual information that you would have found in the CPs was repeated. So essentially, there is the expectation that if you only offer proprietary products, these are some of the controls you could have. And then if you offer both prop and non-prop, then these are some of the controls that you should be considering. But I think, as to your point, I think the regulators are expecting to see more than just a suitability analysis for firms that only offer proprietary products. And I'm just going to pull up the section on proprietary products. And so I think specifically, as you say, it says that we found that firms that only trade in proprietary products rely primarily on performing suitability determinations and providing clients with conflicts disclosure. But in our view, this generally will not be adequate to address these material conflicts of interest in the best interest of the client. And so they went on to provide some controls in those circumstances, one of which, to your point, is about conducting periodic due diligence on comparable non-proprietary products available in the market, and evaluating whether those products are competitive with the alternatives available in the market. They did provide some additional information on the record-keeping requirements when it comes to conducting that comparable assessment. And you can find that later on in the notice under the record-keeping section. But in there, they say that if a firm only sells prop products and conducts this periodic due diligence, then the firm should maintain records to evidence the due diligence, which we would expect one would do. But the due diligence, the comparison, and the evaluation, including which non-proprietary products were examined, and how these compared against the firm's proprietary products, including details as to which factors or attributes were considered for the comparison. So, for example, were you looking at performance? Were you looking at cost? Were you looking at fees, returns, risks? So there is the expectation that not only are you, to the extent that you are conducting this periodic due diligence on comparable products, that you're maintaining record keeping with the level of detail, with at least the level of detail that's outlined in the guidance.
Fantastic summary, Nancy. I really think you truly hit on the core points of this 20-page fine print document that was published fairly recently. And I think it'll set our audience as well as our clients in the right path with respect to this examination findings that's come out. I love the focus and the particular points you call out on the proprietary products as well as non-prop products. Fundamentally, that idea of comparing a range of alternatives from given your product offering, I think brings to life that key core principle of best interest that's behind the intention of the client focused reforms to begin with. So I think it's a fantastic call out. Now, what's next? I know regulators called out specific elements. From your perspective, what should our clients be looking out for on the forefront?
Well, I think the regulators specifically said in the notice that they will be continuing to conduct these reviews throughout the year. So, and it would be on not just the COIs, but also the remainder of the CFR requirements, such as KYC, suitability, KYP, and whatnot. So I think, firms got to be ready for this and if they should be ready, and if they haven't read the notice yet, then they really should get on that very quickly, because this is a hot topic for the regulators. It's definitely a current issue, and they've said that they're continuing to do these reviews. I do hope, one thing that I do hope is that I think that there will be questions on this guidance. I think it's very helpful, but as with any other guidance, you will have questions naturally, and that's why the regulators implemented or established the CFR implementation committee in 2020 to address those questions that the industry might have. I'm hopeful that there will be some sort of avenue, perhaps re-implementing or reinstituting that committee if it's still alive. I don't know, but and maybe even raising additional FAQs, so that to the extent that the committee or the industry still has questions, that they can be able to have a platform on which to raise them.
That's a fantastic point. I can tell you that the FAQs have come up often. I'm talking about the CFR implementation FAQs have come up often in our conversations with our clients, and they do really shed light on some of those call it gray areas in specific. And I think the examination findings advance the conversation, and to your point, but I think it'll be really key for us to kind of keep that FAQ document evolving and updated with more specificity as everybody learns more on the client focused reform file. Absolutely,
I agree.
Nancy, thank you as always for being a part of our conversations. This is truly a great opportunity for us to share some of the great knowledge and learnings we've had on the client focused reforms file. And thank you as always for joining the conversation.
Oh, thank you. No, it's always a pleasure chatting with you about CFRs.
Thank you again for joining today's conversation with Nancy and our Wealth Compliance Leader Series. If you enjoyed the dialogue, please click on following our series via YouTube, Spotify, or other podcast channels.